Criminal procedure and court testimony. 100. Review questions.
Are you ready? 1.
The evidentiary fact by which the ultimate fact is established. A. Factum probans. B. Factum probandum. C. Real or autoptic evidence. D. Circumstantial evidence. A. Factum probans.
2.
The Latin translation of burden of proof. It is a general principle that the person who brings up the case in the court of law is the one who has the burden of proof to prove the claims being made by him. A. Factum probans. B. Factum probandum. Co probandi. D. Onus probandi. D. Onus probandi.
3.
As a rule, leading question is not allowed except A. Preliminary investigation. B. Witness is an adverse party. C. To unwilling or hostile witness. D. Nota. A. Preliminary investigation.
4.
The examination of a witness should be A. Under oath or affirmation. B. Done in open court. C. Both A and B. D. Nota. C. Both A and B.
5.
The following are purposes of cross-examination, except A. To test the witness's accuracy. B. To test the witness's freedom from interest. C. To elicit all important facts bearing upon the issue. D. Nota. D. Nota.
6.
The questioning initiated by law enforcement authorities after a person is taken into custody or otherwise deprived of freedom of action is A. Illegal detention. B. Arbitrary detention. C. Custodial investigation. D. Preliminary investigation. C. Custodial investigation.
7.
Preliminary investigation is required in those criminal cases where the penalty provided by law for the offense charged is A. At least 6 years and 1 day imprisonment without regard to fine. B. Not exceeding 6 years imprisonment regardless of the amount of fine. C. At least for years, 2 months and 1 day of imprisonment regardless of the amount of fine. D. Less than for years, 2 months and 1 day of imprisonment regardless of the amount of fine. A. At least 6 years imprisonment regardless of the amount of fine.
8.
Exclusive original jurisdiction overall offenses punishable with imprisonment not exceeding 6 years. A. Supreme Court. B. Court of Appeals. C. RTC. D. MTC. D. MTC.
9.
The jurisdiction exercised of a country over bodies of land, defined in the Constitution. A. Terrestrial. B. Fluvial, maritime, and interior waters. C. Aerial, atmosphere. D. None of the above. A. Terrestrial.
10.
The English rule is best defined as underscore. A. The crimes committed in a country are not triable in that country, unless their commission affects the peace and security of the territory or the safety of the state is endangered. B. The crimes committed in a country are triable in that country, unless they merely affect things within the vessel or they refer to the internal management thereof. C. Both A and B. D. Nota. The correct answer is B.
11.
The rule as to jurisdiction over crimes committed aboard foreign merchant vessels that is adopted by the Philippines. B. Spanish rule. A. French rule. C. English rule. D. Philippine rule. C. English rule.
12.
The act or omission punishable by law. A. Felony. B. Offense. C. Ordinance. D. Crime. D. Crime.
13.
Courts in the Philippines are clothed with the power or try cases submitted to for adjudication. What term is used in referring to the authority or power to hear and decided cases? A. Jurisdiction. B. Venue. C. Jurisprudence. D. Territory. A. Jurisdiction.
14.
It is the most common way by which the police discovers or is informed that a crime has been committed. A. When the witness voluntarily reports the crime. B. When the police discovers the crime. C. When the suspect surrenders. D. When the victim reports the crime. D. When the victim reports the crime.
15.
When arrest may be made a. At night time. B. At daytime. C. At any time of the day and night. D. Weekdays only. C. At any time of the day and night.
16.
Is the prosecution of an accused before a court, martial bar to another prosecution of the accused for the same offense? A. Yes, military courts and civil courts have concurrent jurisdiction. B. Yes, a person could not be twice put in jeopardy. C. Yes, it is double jeopardy. D. All of the above. D. All of the above.
17.
Jurisdiction over the person of the accused is acquired. Upon his arrest, to his voluntary appearance to the court. 3. If he there was been issued a subpoena against the accused. A. I only. B. To only. C. I and 2. D. I. 2. 3. C. I and 2.
18.
Which of the following cases are within the jurisdiction of our TCA? All cases where penalty is higher than 6 years. B. Laws on libel. C. Appellate jurisdiction over cases decided by the NTC. D. All of the above. D. All of the above.
19.
For valid exercise of criminal jurisdiction, the requisites are following, except A. Jurisdiction over the person of the accused. B. Jurisdiction over the subject matter. C. Jurisdiction over the territoriality where the crime was committed. D. Jurisdiction over the victim. D. All of the above.
20.
The right to counsel is a personal one and therefore may be waived. It is waived when the defendant A. voluntarily submits himself to the jurisdiction of the court and proceeds with his defense. B. refuses to voluntarily submit himself to the jurisdiction of the court. C. refuses to hire his counsel. D. All of the above. The correct answer is A.
21.
When arraignment be held, A. Within 30 days from the date of our court acquires jurisdiction over the person of the accused, unless a shorter period is provided by special law or Supreme Court circular. B. After 30 days from the date court acquires jurisdiction over the person of the accused, unless a longer period is provided by special law or Supreme Court circular. See none of these. D. Both A and B. The correct answer is A.
22.
Preliminary investigation is a statutory right and not a constitutional right. 2. Not an element of due process. 3. It may be waived. A. I only. B. To only. C. 3 and IDI. 2 and 3. D. 1, 2 and 3.
23.
Can the accused demand the right to confront and cross-examine the witnesses during the preliminary investigation? A. No, it is not part of the trial. B. No, it is summary and inquisitorial in nature. C. No, its function is to determine the existence of probable cause and not the guilt of the accused. D. All of the above. D. All of the above.
24.
The additional allegation of conspiracy is what kind of amendment? A. Substantial. B. Formal. C. General. D. All of the above. B. Formal.
25.
For which offenses is the time of the commission of the offense essential? A. Infanticide. B. Abortion. C. Violation of Sabbath day. D. All of the above. A. Infanticide.
26.
It is the application of an art or science. It is the actual performance or application of acquired knowledge. It shows the lawyer how to get there. A. Trial. B. Practice. C. Exercise. D. Theory. B. Practice.
27.
Requisites for a valid exercises of criminal jurisdiction are the following. A. Jurisdiction over the person, the territory, and the subject matter. B. Jurisdiction over the person and the subject matter. ONLYC. Jurisdiction over the person and territory. D. All of the above. A. Jurisdiction over the person, the territory, and the subject matter.
28.
The rules of criminal procedure shall be liberally construed in favor of the accused and strictly against the A. Offended party. B. Accused. C. Complainant. D. State. D. State.
29.
Jurisdiction is determined by the law at A. The time of the commission of the offense. B. At the time when the action was filed. C. The time of arraignment. D. All of the above. B. At the time when the action was filed.
30.
It is rule of conduct or right. It is a rule of action prescribed by the state for the governing of human action. A. Law. B. Practice of law. C. Procedure. D. Trial. A. Law.
31.
A requirement, which is considered as one of the safeguards set down by law to secure and protect the right of the defendant. It is made before the court where the complaint or information has been filed or assigned for trial. A. Trial. B. Prosecution. C. Arraignment. D. Judgment. C. Arraignment.
32.
Arraignment in absentia is not allowed because A. It is a must that the accused is present so that will informed of the nature and cause of the accusation against him. B. He must personally enter his plea. C. He must personally enter his information. D. All of the above. The correct answer is A.
33.
The requirement of the rules on arraignment is mandatory and failure to observe them is ground for A. Dismissal of the case. B. Reversal of the judgment and the remanding of the case for new trial. C. Appeal of the case. D. All of the above. B. Reversal of the judgment and the remanding of the case for new trial.
34.
How much time for counsel d'officio to prepare for arraignment? A. 2 hours before proceeding the arraignment. B. Reasonable time to consult with the accused as to his plea before proceeding with the arraignment. C. 70 to 72 hours before proceeding with the arraignment. D. All of the above. The correct answer is B.
35.
After plea of not guilty, the accused is entitled to such number of days to prepare for trial unless the court for good cause grants him further time. A. 15 days. B. 1 day. C for days. D. 3 days. A. 15 days.
36.
If the accused appears to be suffering from an unsound mental condition that effectively render him unable to fully understand the charge against him and to plead intelligently, A. The arraignment shall be suspended. B. The criminal charged shall be dismissed. C. The trial shall be suspended. D. All of them. A. The arraignment shall be suspended.
37.
The prosecution is required to present evidence and the sworn statement of each proposed state witness at the hearing in support of the discharge is admissible in evidence. Thus, the motion to discharge the accused to be state witness must be filed, A. Before the prosecution rests its case. B. Before the presentation of evidence. C. For the first time on appeal. D. Before arraignment. A. Before the prosecution rests its case.
38.
The legal effect if and when all agreements made or entered during the pretrial conference, which are reduced in writing, are not signed by the accused and his counsel. A. It is considered as admission of guilt. B. Cannot be used against the accused. C. The court shall order for another pretrial conference of the case. D. All of the above. B. Cannot be used against the accused.
39.
The general rule is that the civil action is not necessarily extinguished by the acquittal of the accused. Even if the accused is acquitted, the court can still award civil liability when A. The acquittal is based on reasonable doubt. B. There is a declaration in the decision that the liability of the accused is only civil. C. When the civil liability is not based on the act of which the accused is acquitted. D. All of the above. D. All of the above.
40.
The independent civil actions are those provided in Articles 32, 33, 34, and 2176 of the Civil Code. They may proceed independently of the criminal action, and they shall require evidence. A. Independently. B. Substantial. C. Preponderance. D. All of the above. C. Preponderance.
41.
The civil action is not deemed instituted when a. The offended party has waived the civil action. B. The offended party has instituted the civil action prior to the institution of the criminal action. C. The offended party has reserved the right to institute the civil action separately. D. All of the above. D. All of the above.
42.
Civil liability includes or constitutes A. Restitution. B. Reparation. C. Indemnity for consequential damages. D. All of the above. D. All of the above.
43.
In which offenses is the particular place where the offense was committed indispensable? A. Violation of domicile. B. Trespass to dwelling. C. Violation of election law by carrying of a deadly weapon within a 30-meter radius of polling places. D. All of the above. D. All of the above.
44.
A complaint or information must be charged only one offense, except when the law provide only one punishment for various offenses. A. Compound crimes. B. Special complex crime. C. Complex crimes. D. All of the above. D. All of the above.
45.
Jose fired his gun, but the bullet to persons what crime he commit? A. Complex crime. B. Special complex crime. C. Compound crime. D. All of the above. C. Compound crime.
46.
The information against an accused is amended by adding additional allegation of habitual delinquency and recidivism. This is underscore amendment. A. Formal. B. Substantial. C. Substantive. D. General. B. Substantial amendment.
47.
The change in the nature of the offense due to supervening event is underscore amendment. A. Substantial. B. Formal. C. General. D. All of the above. B. Formal.
48.
The following may conduct preliminary investigation, except A. Ombudsman with respect to Sandigan offenses. B. National and State Prosecutor. C. Comlec with respect to election cases. D. RTC Judge. D. RTC Judge.
49.
The rules of procedure shall be construed. A. Strictly against the state. B. Strict application should be eschewed. C. Spanish text prevails over English text. D. All of the above. B. Strict application should be eschewed.
50.
For valid exercise of criminal jurisdiction, the requisites are A. Jurisdiction over the person of the accused. B. Jurisdiction over the subject matter. C. Jurisdiction over the territoriality where the crime was committed. D. All of the above. D. All of the above.
51.
Is an inquiry or proceeding to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial probable cause. A. Custodial investigation. B. Inquest proceeding. C. Preliminary investigation. D. Arraignment. C. Preliminary investigation.
52.
What is the stage in court proceedings where the prosecution and accused may agree on matters what will promote a fair and expeditious trial of the case? A. Trial proper. B. Preliminary investigation. C. Inquest proceedings. D. Pre-trial. D. Pre-trial.
53.
Among the rights of the accused, which is not a constitutional right: A. Right to speedy trial. B. Right to counsel. C. Right against self-incrimination. D. Right to appeal. D. Right to appeal.
54,
Lupang Tagapamayapa is composed of Barangay Captain as its chairman and B. 3 members, B. 5 members, C. 5 to 10 members, D. 10 to 20 members. D. 10 to 20 members.
55,
Is the formal reading of the charges against a person accused of a crime and latter asking him whether he pleads guilty or not to the crime charged. A. Arraignment. B. Preliminary investigation. C. Plea. D. Promulgation of judgment. 8. Arraignment.
56,
In Manila, the complaint is filed with the A. Office of the President, B. Office of the Clerk of Court, C. Office of the Prosecutor, D. Office of the Ombudsman. C. Office of the Prosecutor.
57,
Exclusive original jurisdiction over all offenses punishable with imprisonment not exceeding 6 years. A. Supreme Court, B. RTCC, Court of Appeals, D. BMTC. D. MTC.
58,
Is an inquiry made by the duty prosecutor to determine the legality of the arrest made, especially those arrests made without a warrant. A. Custodial investigation, B. Inquest proceeding, C. Preliminary investigation, D. Arraignment. B. Inquest proceeding.
59,
Who is the chairman of the Lupang Tagapamayapa in the barangay level where there's a diversion program? A. Panong Barangay, B. BCPC chairman, C. LSWDO, D. PNP member. A. Panong Barangay.
60,
In order to determine the veracity of the testimony of the witness against him, the accused has the right to testify on his own behalf, B. Secure the presence of his witnesses in court, C. Has the testimony of the witnesses against him, D. Cross-examine and confront the witnesses against him. D. Cross-examine and confront the witnesses against him.
61,
What is this right that the accused may invoke during trial to avoid statement against himself? A. Right not to be witness for his behalf. B. Right against self-incrimination. C. Right to assistance of counsel. D. Right to remain silent. B. Right against self-incrimination.
62,
Which among the following illustrates order of trial? A. Prosecution, defense accused, rebuttal, surrebuttal. B. Rebuttal, surrebuttal, prosecution, defense accused. C. Prosecution, rebuttal accused, surrebuttal defense. D. Defense, prosecution, rebuttal, surrebuttal. A. Prosecution, defense accused, rebuttal, surrebuttal.
63,
When should the accused be informed of Miranda rights? A. Before he is put into custody. B. After he was asked any question related to crime he was arrested for. C. Immediately after he is arrested. D. When he is already assisted by a counsel of his choice. C. Immediately after he is arrested.
64,
It is a body of men created to settle disputes within barangay level. A. Barangay Tanod, B. Pangkat Tagapakasundo, C. Barangay Council, D. Lupang Tagapamayapa. D. Lupang Tagapamayapa.
65,
Which is the correct order in the examination of witnesses? A. Direct, redirect, cross, recross examinations. B. Direct, cross, redirect, recross examinations. C. Cross, redirect, direct, recross examinations. D. Redirect, direct, cross, recross examinations. B. Direct, cross, redirect, recross examinations.
66.
It refers to the questioning initiated by law enforcement officer after a person has been taken into custody. A. Custodial investigation. B. Interview. C. Inquest. D. Interrogation. A. Custodial investigation.
67.
The remedy to a duplicitous information is to file a motion to quash. A. Before arraignment. B. After. A. Before arraignment.
68.
The offender is a police officer with the rank of superintendent. The crime committed is in violation of the anti-graft law. The case shall be under the jurisdiction of the A. Metropolitan Trial Court. B. Regional Trial Court. C. Office of the Ombudsman. D. Sandigan Bayan. B. Regional Trial Court.
69.
This court was established by virtue of PD 1083, otherwise known as Code of Muslim Personal Laws of the Philippines. A. Court of Tax Appeals. B. Sharia Court. C. Sandigan Bayan. D. Family Court. B. Sharia Court.
70.
In cases committed by public officers with salary grade 27 and above in violation of Act 3019, RA 1379 or Art. 210 to 212 of the Revised Penal Code, a complaint should first be filed to the Office of the Conduct of the required investigation. For the preliminary tur, A. Ombudsman. B. Solicitor General. C. Judge of MTC. D. Sandigan Bayan. Default texta.
71.
After the decision was rendered be the court disposing of the case, which of the following remedies allows the presentation of new evidence? A. Motion for reconsideration. B. Motion for new trial. C. Notice of appeal. D. Petition for review. B. Motion for new trial.
72.
Which of the following cases are within the jurisdiction of RTC? A. All cases where penalty is higher than 6 years. B. Laws on libel. C. Appellate jurisdiction over cases decided by the MTC. D. All of the above. D. All of the above.
73.
It is defined as an accusation in writing charging a person with an offense subscribed by the fiscal and filed with the court, a criminal action. B. Information. C. Complaint. D. Police blotter. B. Information.
74.
A complaint of adultery or concubinage may be filed only by A. Investigating police. B. Offended spouse. C. Prosecutor. D. All of the above. B. Offended spouse.
75.
The change in the nature of the offense due to supervening event is underscore amendment. A. Substantial. B. Formal. C. General. D. All of the above. B. Formal.
76.
A complaint or information must be charged only one offense except when the law provide only one punishment. For various offenses, A. Compound crimes. B. Special complex crime. C. Complex crimes. D. All of the above. D. All of the above.
77.
It means the proceedings in open court or while court is in session after the pleadings have been filed and the case is otherwise ready for hearing up to and including the rendition of judgment. A. Trial. B. Practice. C. Pre-trial. D. Law. A. Trial.
78.
The system of criminal procedure. A. Inquisitorial. B. Mixed, eclectic. C. Accusatorial. D. All of the above. D. All of the above.
79.
What is the remedy of the accused if the court denies his motion to quash? A. He should plead and proceed to trial. B. He should appeal. C. He should plead. D. All of the above. A. He should plead and proceed to trial.
80.
The different kinds of plea are A. Conditional plea and unconditional plea. B. Negative indirect plea and improvident plea. C. Reverted plea. D. All of the above. D. All of the above.
81.
It is said to exist when the complaint or information sets out an offense, but the evidence establishes another. A. Complex crimes. B. Continuing offense. C. Variance. D. False accusation. C. Variance.
82.
It is a plea of guilty by the accused without any condition or reservation. A. Unconditional plea. B. Improvident plea. C. Reverted plea. D. Acquittal. A. Unconditional plea.
83.
It is the analysis of a set of facts in their ideal relation to one another. It tells or guides the lawyer where to go. A. Theory. B. Practice. C. Law. D. Practice of law. A. Theory.
84.
It is rule of conduct or right. It is a rule of action prescribed by the state for the governing of human. A. Ctiona law. B. Practice of law. C. Practice. D. Trial. A. Law.
85.
The rules of criminal procedure shall be liberally construed in favor of the accused and strictly against the A. Offended party. B. Accused. C. Complainant. D. State. D. State.
86.
It is the application of an art or science. It is the actual performance or application of acquired knowledge. It shows the lawyer how to get there. A. Trial. B. Practice. C. Practice of law. D. Theory. B. Practice.
87.
For which offenses is the time of the commission of the offense essential? A. Infanticide. B. Abortion. C. Violation of Sabbath day. D. All of the above. A. Infanticide.
88.
All evidence submitted in court to prove facts in issue are admissible. This statement is incorrect. A. True. B. Untrue. C. Partly true. D. Partly untrue. A. True.
89.
This allows evidence seized by state officers in an illegal search and seizure to be used against the accused in a criminal trial, a waiver or consented search. B. Plain view. C. Silver platter. D. In flagrante delicto. C. Silver platter.
90.
It refers to the distance and the facility of access between the situs criminis site of the crime and the place where he says he was when the crime was committed. A. Legal impossibility. B. Impossible crime. C. Physical impossibility. D. Alibi. C. Physical impossibility.
91.
The oral confession of Cardo while in the police custody is admissible as A. Judicial admission. B. Judicial confession. C. An extrajudicial confession. D. An extrajudicial admission. C. An extrajudicial confession.
92.
It exists when the drug is under the domination and control of the accused or when he has the right to exercise domination and control over the place where it is found. A. Actual possession. B. Constructive possession. C. Illegal possession. D. All of the above. B. Constructive possession.
93.
Negative testimony normally enjoys more weight than a positive testimony. A. True. B. False. C. Partially true. D. Partially false. B. False.
94.
It is one kind of evidence when the witness affirms that a fact did or did not occur. A. Positive evidence. B. Negative evidence. C. Secondary evidence. D. Primary evidence. A. Positive evidence.
95.
These are additional evidence of different character tending to prove the same point. A. Corroborative evidence. B. Cumulative evidence. C. Testimonial evidence. D. Documentary evidence. B. Cumulative evidence.
96.
Evidence is admissible in court if it is A. Competent. B. Relevant. C. Material. D. All of the above. D. All of the above.
97.
Also known as but for taint doctrine. A. Exclusionary rules. B. Search warrant. C. Doctrine of fruit of poisonous tree. D. Warrant of arrest. C. Doctrine of fruit of poisonous tree.
98.
It is a kind of evidence that is not excluded by law in a particular case. A. Competent evidence. B. Material evidence. C. Direct evidence. D. Circumstantial evidence. A. Competent evidence.
99.
Evidence directed to prove a fact in issue as determined by the rules of substantive law and pleading. A. Relevant evidence. B. Material evidence. C. Direct evidence. D. Circumstantial evidence. A. Relevant evidence.
100.
Is the tendency of the evidence to establish the proposition that it is offered to prove? A. Probative value. B. Admissibility value. C. Sanctioned. D. All of the above. A. Probative value.
Comment your score.
Study smarter, not harder. Subscribe for more.